Good afternoon, everyone. My name is Alexis Alvarez, and I am the Director of Statewide Training at Florida Legal Services. I'm excited to invite you and have you here today for a training on navigating the evolving PACE landscape, a working discussion of the tools available to assist and protect consumers. Before we get into the content today, I always want to remind you of a few housekeeping announcements. First and foremost, this is being recorded. A copy of the recording will be sent to you all after the event, usually within 24 hours. That comes from an automatic email via Zoom. So it should hit your inbox. If it doesn't, I'm going to drop my email into the chat, and you can always reach out to me directly to get anything that you need. Second piece of housekeeping announcements, this training is approved for CLE credit through the Florida Bar. At the end of the presentation, I will drop that CLE code into the chat. I will also announce it out loud, and I will also ensure that it is written in that email that comes to you from Zoom along with a copy of the recording. Third piece of housekeeping announcements, closed captionings. Your closed captions are available for anyone that needs a little bit of that extra accessibility. All you'll need to do is probably click more at the top, 3 bubbles, and that will give you some options to show captions. If you're having any issues with that and you can't get that onboarded, again, I'm going to drop my email into the chat. Feel free to reach out to me. I'll be checking my email throughout. The final piece of housekeeping announcements are questions and answers. I always say this, it's the virtual vortex. It's hard to feel connected. It's hard to feel that we're in one community in one space, but we are, and so we want to hear from you. Don't be shy. Drop your questions, preferably in the Q&A. That way we can filter them more effectively. But if you put it in the chat, we'll grab it. Don't worry. But please don't be shy. We know that this is an evolving landscape with a lot of just questions. So drop them in. Don't be shy. We want to hear from you. And with that, I'm going to turn it over to Laura Boeckman to do some introductions of our sponsors here today, and to also introduce the incredible lineup of speakers that we have. Laura, thank you.
Thanks, Alexis. So I'm Laura Boeckman. I'm the chair of the Public Interest Law Section's Consumer Housing Work Group. And we're very happy to help put this CLE on today. And it's my pleasure to introduce a very impressive lineup of speakers. So first we have Chasity Osteen. Chastity's the county attorney for the city of Tallahassee. And she's been in that position, for Leon County. And she's been in that position since April of 2020. Prior to her appointment, she served as the general counsel of the state of Florida's Department of Management Services and Department of Financial Services. She received her bachelor and Juris Doctorate from Florida State University, and she has represented state and local governments in a variety of areas, including ethics, procurement and contracts, public records, federal and state grant funding. She's also a member of the executive committee of the city, county, and local government sections of the Florida Bar. So we're very happy to have her here today. We also have Ellen Sheik, who is with Bay Area Legal Services. She has been with them since 1975 as a staff attorney and has focused on elder law issues, and it is a senior advocate. And since 2005, she's been with Bay Area Legal Services. Sorry, Ellen. And she's also the Florida Elder Justice Coordinator and co-chair of the Florida Bar Elder Law Section's Abuse, Neglect, and Exploitation Committee. And finally, we have Lynn Drysdale, who I feel like needs no introduction. But for those who are not familiar with Lynn, she has been with Jacksonville Area Legal Aid for over 3 decades, where she represents consumers in individual and class cases and engages in legislative advocacy related to debt collection, payday loans, spot delivery, motor vehicle sales and financing, military pension loans, automobile title loans, and the list goes on. And most recently works on PACE issues as well. In fact, she is on her way back from Tallahassee this afternoon, where she was at a hearing this morning on PACE loans as well. And so Lynn will be giving us a little bit of a legislative update. Excuse me. So with that, I will turn it over to Lynn to let us know what's going on in the legislature regarding PACE loans.
Thank you, Laura, and thank you to the other presenters. I was very excited about this program. So the PACE program we learned an awful lot about in our last webinar last month. It's a program that's supposed to provide funding for clean energy through local governments. Well, last session, I'll just start there. There was a bill introduced that would expand the use of PACE to different types of like septic and things like that. And it was also, we were concerned because it didn't provide much in the way of consumer protection. So what you have is a bill that creates a super lien, which trumps your mortgage, and for which the monthly payments are paid only through tax assessments. We lobbied against the bill last year because there were no consumer protections, and it was a done deal pretty much. Every single committee it went to overwhelmingly was voted favorably. So we just knew the bill was done. We went to bed at Sinai, and then we wake up the next morning and there's no bill. And I'm sure Chasity and Laura and everyone else or particularly Alice Viggers, could explain this better than I. But anyway, we thought we had lost and we somehow won. So what will happen next is what Chastity's going to talk about. But I will just very briefly say that there's a bill going through. It's passed the Senate. A very similar bill has passed the House, attempting to deal with some of the issues that have come up since last session. I'm pretty certain the bill will pass. It has some consumer protections, but it's not the consumer protection boon that they were hoping. For instance, and I'll only mention one, there are no truth in lending disclosures required at any point in the process.
All right, Chastity, oh, sorry, Lynn, were you done?
No, I was just gonna pass the torch, but
Okay. So,
oh yeah, so now
go ahead, Lynn.
I have been looking forward, just for me, to hear Chastity talk for at least a year now, I know. So I'm very excited to hear what her tell us what they've been doing, how we can help if at all possible. So I'm very much looking forward to this. Thank you.
Good afternoon, everybody. So I really started learning a lot. I knew generally about the PACE program for a while, but really in the last like 3 years or so, I started digging into it more because Leon County has historically allowed residential and commercial PACE within this jurisdiction. But one of the residential providers, our only residential provider, basically left the market. And so our sustainability staff started looking for a new PACE provider, specifically for residential, but really could cover both, to really fill that void. And in the process, looked at best practices for consumer protections and things around the state and some other jurisdictions have been doing to really kind of ensure consumer protections more than the what I'll call very bare minimum of what is included in state law currently for consumer protection. And so in the course of that, we came across a special district called the Florida PACE Funding Agency. And they're a governmental entity. They do provide PACE in different jurisdictions. And so our staff was comfortable with them, communicated with them, and started developing an ordinance that would govern their operations here in Leon County. And so in this would have been 2022. We brought a resolution to our board to authorize Florida PACE Funding Agency to provide a residential and commercial PACE within certain restrictions, imposing certain requirements, and that sort of thing to our board. Passed. Well, we ultimately heard back from the Florida PACE Funding Agency, and they said, hey, we would like some tweaks to the resolution. And so we worked with them over time. As most of you know who work with government, nothing happens fast. But ultimately, in the fall of 2022, brought back a resolution that we had worked with Florida PACE Funding Agency to finalize, and received a communication from their attorney to say, is this good? Because, you know, we don't want to bring something to our board that you guys aren't comfortable with. And the response back was, we have no issues with it. So brought it to our board. Again, unbeknownst to Leon County, Florida PACE Funding Agency had initiated a bond validation proceeding. So as many of you know, the way this program works and financing for many types of governmental entities, so bond validations are really not uncommon, is basically to get the court to validate or approve bonds for certain types of activities, and there's statutory requirements and all this other sort of stuff. And again, Florida PACE Funding Agency had, initiated and obtained bond validation final judgments in the past too. Nothing seemed untoward about that. So Florida PACE Funding Agency specifically was created by interlocal agreement of Flagler County and the city of Kissimmee. And so for this bond validation proceeding, statutorily, they were required to basically publish notice in both of those jurisdictions in the paper, and then also in Leon County, because under Chapter 75 of the Florida statutes, many bond validation proceedings had to be filed in the Second Judicial Circuit, Leon County, Florida. So they also published notice in the paper here, and then they served the state attorney's offices in those jurisdictions, in those circuits, which is interesting. In my previous legal career, I started out in private practice as counsel for community development districts, which are special purpose local governments, and they issue bonds as well, and they go through this bond validation process. So I'm familiar with this process, but something that FPFA did in this case, which was unusual, is bond validation proceedings are limited in scope. And the court, and this is based on case law, is only supposed to consider matters, and it's enumerated in the case law, matters directly related to the entity's ability to issue bonds. Okay. Well, what Florida PACE Funding Agency did in this case was, when they filed the bond validation proceeding in their complaint, in their memorandum of law, and ultimately in the proposed final judgment that they provided to the judge here, that he signed off on, it included findings related to their authority to operate autonomously and allegedly without oversight or regulation by any local government in any local jurisdiction anywhere in the state of Florida. So again, no counties or cities received any sort of notice about this bond validation proceeding or these allegations. If you looked at the notice that was published in these papers, these 3 papers, they were just run-of-the-mill bond validation notices. And there was no language in those notices that would have put anybody on notice that FPFA was asserting this jurisdictional issue, and that they were asking the court to decide that and basically make these findings as part of the bond validation proceeding. So our board, after they'd actually filed that bond validation proceeding, while it's pending, based on our communications with FPFA, our board actually approved our resolution authorizing FPFA to operate here, subject again to those requirements and limitations in the resolution. So we were unaware that, like many jurisdictions, that any of this is going on. So fast forward, the first indication of what FPFA had done, and basically procedurally, once a court issues a final judgment in a bond validation proceeding, there's a 30-day appeal period. Appeals go directly to the Florida Supreme Court. It's expedited. Of course, nobody knew what was happening. Nobody tried to intervene. In fact, parties who have standing to intervene in bond validation cases is pretty narrow in some respects. So appeal period runs. FPFA just starts issuing bonds. They start operating in all of these jurisdictions. I believe the first notice of lien was filed in Leon County within days after the appeal period had run. And again, we had no idea. So they just start operating. Meanwhile, Leon County staff has reached out and tried to communicate at different times during this with FPFA staff to say, hey, we want to get a plan together, a rollout, figure out, when your operations are going to start, coordinate all this stuff. And they kind of put us off for a while until the beginning of January of 2023. We get our letter, which says, hey, great news. We have this bond validation final judgment where the court has said, we don't have to abide by any of your regulations. We can operate autonomously in your jurisdiction, and we plan to do so. But hey, if you want to enter into an interlocal agreement, here's the form of the interlocal agreement that we'll enter into with you. And we'll keep you guys posted about what we're doing, basically. That's not exactly the verbiage, of course, but that was the gist of the communication. And of course, the ILA that they proposed said exactly what they were taking as their position, which is you guys acknowledge and agree that we have authority to act with complete autonomy in your jurisdiction. You have no control or oversight of us, and we'll give you guys a report once a year, was basically what they proposed. So needless to say, we were a bit surprised. And unbeknownst to us, also at the time, these letters were being sent out to different jurisdictions all over the state. So one of the first things I did was I contacted Ginger Delagal, who is the executive director over at the Florida Association of Counties. And I was like, what is happening? Has anyone else received a letter like this? And so they start checking around and all of that stuff. And I think I actually saw something on one of the listservs like, hey, has anyone gotten one of these? And the first time I saw that, it was before we received our letter. I wasn't really concerned because, again, necessarily, Florida PACE Funding Agency would need to issue bonds, even to operate their program in Leon County. So I wasn't concerned because, again, I had no idea they were going to take the position that they weren't subject to our regulation or would have to comply with the resolution we just adopted. So over time and talking with different people and starting to coordinate, and really shout out to a lot of the county attorney's offices and FAC as well. There was a FACA PACE task force was created to try to start wrapping our arms around what was happening, who was getting the notice or the letter, how different jurisdictions were trying to respond to it. There was a lot of consternation. This CLE is not about bond validations, but you have to understand under the case law, once a bond validation final judgment has been issued and the appeal period has run, typically there is no opportunity for appeal. Like you're done. There is no legal recourse to challenge that after the fact. So we were all doing a little bit of research, trying to figure out what we could each do. A couple of the jurisdictions, and basically it's been a little bit of a mess since then. That's probably an understatement, but multiple jurisdiction has resulted from this. Pinellas County was the first jurisdiction in April of last year to file litigation. FPFA immediately filed a motion to dismiss through a bunch of different arguments out there, one of which was jurisdiction. And the court there ruled in favor of FPFA that's now, I won't say stuck, but it is, even on that singular narrow issue, that's before the second DCA to even just issue an opinion on the jurisdiction issue before that case can proceed. So of course, Pinellas County had at the time an ordinance regulating the authority of any providers to operate PACE in Pinellas County. And in fact, it's kind of a patchwork all over the state, right? Because the different local jurisdictions have adopted their own regulations as they're authorized to do. And we firmly take that position under 163.08. And so they had an ordinance, we have a resolution. Some jurisdictions have prohibited it completely. Some just allow it. I mean, it is a patchwork of regulation. So again, part of the difficulty here was figuring out what everyone's regulations even look like, how different jurisdictions are going to be impacted. Pinellas County came out fairly quickly, trying to challenge it. It's just bogged down at the circuit court level and litigation and the second DCA for the jurisdiction issue. Palm Beach County followed suit as well. Basically, they just received kind of a similar decision at a circuit court there on the standing issue. It's currently on an interlocutory appeal, and they've briefed it as of mid-February, and now again that's in process. But that's again an example of bureaucracy, the judicial system. All of these things take time. These things do not move quickly. And during this, everybody now knew to go and look at the public records and see notices of lien that were getting filed. In different jurisdictions, the FPFA has been operating very aggressively. Leon County has less than 20, I'll say. Other jurisdictions, hundreds or thousands. And so on the county side, there was very much a sense of urgency to try to stop this. But there are the tools in the toolbox on the judicial side, again, things to not to move quickly, especially, not surprisingly, Florida PACE Funding Agency has to really try to slow down litigation against them in the different jurisdictions. Orange County has filed suit. Since Volusia County has filed suit, Leon County has filed suit, Jacksonville has filed suit, Broward County, and Lake County. So a number, or Broward County has not. Let me clarify that. Broward County has not filed suit. They're doing a couple of different things. They do have authority to file suit, but they're working to amend their ordinance about the PACE programs and consumer protections and things like that. So they have not actually initiated litigation at this point. So basically, but across the board, in all of that litigation, which FPFA has actually responded, FPFA has been using that bond validation final judgment as a shield, right? They're asserting that because that was decided as part of the bond validation proceeding, that it's not, that no court or no party can really attack their authority, that they're foreclosed because the final judgment in the bond validation proceeding is final. So, but what they also have been doing it is using it as a sword, if you will, against tax collectors around the state. So this was mentioned briefly at the beginning of the CLE that the sole method of collection statutorily for these assessments is on the tax bill. And of course, the tax collectors are the one who place the taxes and assessments on the tax bill, on the tax roll. So when the tax collectors got wind of what FPFA had done and determined that they hadn't met certain procedural requirements, and also that FPFA did not have or had terminated interlocal agreements and did not have authority to act within these jurisdictions, across the board, the tax collectors took the position that these were not permissible assessments, and they refused to place them on the tax roll. Now, what that has resulted in, again, is it has spawned additional litigation where Florida PACE Funding Agency has sued different tax collectors in different jurisdictions. The Alachua County tax collector, Hillsborough County, Bradford County, Union County, Volusia County, Sarasota County, Leon County, we're in that too, St. Lucie County, and also Hernando County. So that litigation has been ongoing as well. Many of the courts that have considered these cases where Florida PACE Funding Agency has basically filed writs of mandamus and trying to compel the tax collectors to collect, except for one jurisdiction so far has determined that no, there's a dispute about whether these are permissible assessments and refuse to issue the writs. Now, some of those cases are final and have not been appealed by Florida PACE Funding Agency. Some of them are in process, and some of them have been appealed. So the one in Volusia County, that notice of appeal was filed by FPFA. That is in process currently. The Sarasota County case, the judge there actually entered the writ, but then a petition for rehearing or motion for rehearing was filed. They've actually gone back, held an evidentiary hearing. That case was actually subsequently stayed by the parties pending the outcome of what I'm about to talk about that's currently going on in the bond validation proceeding here in Leon County. St. Lucie County, that one's still pending. Ours has been stayed. And then in Hernando County, the judge there actually determined, no, these are valid assessments, issued the writ, and a motion for rehearing in that case was filed by Hernando County, and I believe the tax collector there in December, and that's still pending. Now, if you look at your calendar, yes, it's mid-February or almost late February, and that motion for rehearing was filed months ago. But again, it's still pending. None of this stuff moves very fast. So Leon County, we have a small but mighty legal office, did not and does not have the capacity to litigate a case like this in-house. So we retained outside counsel, great counsel, and we've been working with them. And one of the things that we came across was a rule of civil procedure, rule 1.540. And what that rule generally says is after an order, decree, final judgment has been issued, if one of the enumerated bases is met, you can file one of these motions and request relief from the order, decree, or final judgment. We looked at that, but we considered that to be kind of the nuclear option, and really wanted to push the litigation in the different jurisdictions, in part, again, because it's a patchwork. You know, some have ordinances, some have resolutions, some of them had no regulations, some of them had complete prohibition. So factually, even the underlying local government regulation is not consistent. Also kind of complicating it a little bit is, for example, in Monroe County, where FPFA did have an interlocal agreement, they didn't immediately terminate it like they did in a lot of other jurisdictions. They basically, FPFA sent Monroe County the letter that said, hey, but we're going to go ahead and keep our interlocal agreement in place and comply with it until it expires like in mid-2024. They did something similar in Collier County too. So even the way FPFA characterized that as doing it voluntarily, complying voluntarily, but they weren't treating the counties all the same. And so again, we were trying to see how the litigation was going to go in the different jurisdictions. None of that was going fast. None of that was really going anywhere. Like for hours, we'd requested, expedite emergency review and a motion for an emergency injunction. Well, in fairness, a lot of people think that their issue is the most pressing issue and an emergency. And basically we were told by the judge, and in our case, yeah, if I believed everybody who said this issue was an emergency, everything would be an emergency, which when I get the request from my clients, sometimes I feel that way too, right? Everybody feels like their issue is the most important thing and needs to be addressed right now. And so basically, enough of the counties who were trying to get this behavior to stop, at least for the time being until we could get this sorted out, realized that none of that was really going to happen in the short term. Meanwhile, FPFA is operating. They're still issuing tons of bonds. They're still making these contracts, or at least their financial administrators are entering into these contracts with contractors. Contractors are doing this work for people. And again, it's like the Wild Wild West. It's totally open. And so we pivoted basically, and we collectively filed this joint motion. Now, we can't be parties to a bond validation proceeding. That's just based on case law because it's supposed to be limited in scope and everything else. So we just filed as joint movements, and there were, okay, I'm gonna estimate here. I think there were 14 counties, almost 40 tax collectors' offices, and then we actually communicated with and got the 3 state attorneys' offices who had initially participated in the bond validation to join in our motion, along with 3 other state attorneys' offices for other circuits who had gotten wind of this issue and realized that perhaps the bond validation process had been utilized in an improper way, and that this collateral issue had been decided improperly and that the court did not have jurisdiction. So October of last year, we filed the joint motion, and we were, of course, and it reopened the bond validation proceeding. So what's very important is procedurally, we are not asserting that the bond validation final judgment is void. We're not trying to attack or get the court to make any other determination about the core permissible issues that are decided in bond validation proceeding. We are asserting that this issue specifically was collateral, that the court lacked personal jurisdiction. It decided the rights of counties, tax collectors, others, which is not permissible in a bond validation proceeding because we're not parties. That this was a collateral issue, that the court lacked jurisdiction to do so. And we also asserted, and I think through the course of this litigation and even some of their testimony at the evidentiary hearing that was held in this case earlier this month, they meant to have the court make these findings because they were banking on no one knowing about it, no one finding out before the appeal period ran, and them just being able to argue anyone is forever foreclosed from attacking it. So we have that case pending. It's been a bit of a slog, but it's actually moving fairly quickly as in terms of litigation. We held a case management conference in the beginning of December. The court did issue an order establishing timelines, which was good. We filed, of course, our motion. FPA filed its response. Then we had an intervener. So each of the PACE providers, many of them, at least the special district ones, deal with financial administrators. Fortify and Home Run were 2 of the residential ones who operated for Florida PACE Funding Agency. 4 to 5 moved to intervene. We think it was improper. Court ultimately granted it. But basically, we all filed our written pleadings, our objections. We actually, like a day or two before the evidentiary hearing, again, that was held February 2nd of this year, stipulated to a lot of what was in some of the affidavits that were attached to our motion that was filed to reopen and make these allegations. But yeah, I mean, it's jurisdictional argument, and it's an argument that they basically misrepresented and committed fraud on the court. So that evidentiary hearing was held. There was some testimony. Like I said, there was some stipulation as well. The court ended up, for the most part, not ruling from the bench on the issues. The only verbal ruling, which still isn't in writing yet, was to basically dismiss the motion as to the 3 state attorneys' offices that initially participated in the bond validation proceeding. Again, under the rules and the case law, we don't think that was proper. We will have an opportunity to try to point that out to the court, because what the court did was say, okay, within 30 days, each party will provide final written closing argument and proposed orders. So we're on the clock for that. We have a couple more weeks before that will be filed. I should also disclose that separate counsel was hired by 2 of the counties and 2 of the tax collectors, and they filed their own motion. So there were 2 different motions that were filed in this case. And so they will also be provided an opportunity to present their final written closing arguments and proposed final orders, just like Fortify's counsel and FPFA will. And then we'll see what the court does. At that point, then it will become interesting to see if someone wants to take this issue up on appeal, whether it gets expedited up to the Supreme Court because it's in the context of a bond validation proceeding, or whether it'll have to go through the First District Court of Appeal first. And I'm sure there will be potential argument both ways on that issue. It has been alleged and represented in the course of this case that Fortify has issued, or FPFA has issued $150 million in bonds, commensurate with the amount of PACE work that has been done around the state since the bond validation final judgment was entered. And from the public records requests that have been fairly limited, but that we've made and been able to obtain information for, they're issuing bonds, at least they were, like several times a week, to keep up with the pace of demand, no pun intended on that. So that's kind of a quick summary of how this Florida PACE Funding Agency issue kind of occurred, how it's evolved. It's very unsettled right now, even assuming either at the circuit level and or DCA, and ultimately maybe the Supreme Court level. If we prevail, there's still very much the question of what happens to those liens that have been filed and recorded as a result of the work that's been done. And also the payment of outstanding bond debt. So those are some of the legal issues associated with this. I know part of this is to talk about consumer protection and that sort of thing, but this kind of sets the stage for how we ended up in what I'll characterize currently as this mess that we have legally right now. And I do also, in fairness, want to say, since this is a PACE webinar, I've been focusing on Florida PACE Funding Agency almost exclusively. Some of the other PACE providers have reached out. They have not taken the same position that Florida PACE Funding Agency has with respect to their authority to act autonomously statewide without having interlocal agreements in place and that sort of thing. It's my understanding that they are also supporting the legislation that is currently pending, which would include, it was in the Senate version, it's now been added to the House version, would require that PACE providers have those interlocal agreements in place with the county or municipality where they want to operate. So it would be very express in the statute if the amendment is adopted this session. But I've rambled a bit. Hope people could follow that. Happy to answer any questions anybody has.
Thank you, Chastity. Laura?
Thanks, Chastity. Ellen, you want to dive in with some tips for how to interview potential PACE clients?
Yeah, so thank you, Chastity, for that incredible overview. So as you've just heard, there is an incredible amount of litigation occurring up here that challenges the authority of Florida PACE Funding and agency and the tax collector's role in all of this. But as Chastity said, the PACE salespeople are still working fast and furiously down here. And they are, for that reason, we thought it would be a good idea to review some points to be covered during an initial intake with an actual PACE customer who might come your way. And we're gonna, I think that fact development in these cases is so important, not just because the facts are triggers for certain individual lawsuits that might be used to pursue some relief for these people, but also because the facts paint the most compelling stories for advocates who in turn go to legislators and policymakers to try to ensure that we develop some consumer protections around these loans. So I'm going to go very quickly through some points that I think should be covered during an initial intake interview, and I will. I'm going to go quickly because for time's sake, but I will send out a checklist if that's helpful to people after the webinar that you can adopt in your own practices. So first of all, how do you know you've got a PACE transaction or a PACE customer sitting in front of you? Well, the first clue is the improvement itself. Is it a PACE eligible improvement? That means only certain home improvements can be financed through PACE. And they're basically storm hardening improvements like wind-resistant windows and doors, roof replacements. And they also involve energy efficient enhancements or energy efficiency enhancements like solar panels. So if the improvement itself qualifies, then you go on to the next and probably simplest indicator. Has the client been asked to pay anything for an improvement that's already been either is in progress or has been installed? The reason it's such a big indicator is that the bill in a PACE transaction, as Chastity and Lynn have mentioned, is the tax bill. There can be a considerable lag between the work done at a consumer's house and the receipt of a tax bill. So if a client says that they gave money for a down payment for materials, for example, or they paid one third over the course of a construction project, it's not PACE. Conversely, if the client insists they've not paid anything and haven't been asked to do so, and there is a home improvement project that's either been in process or completed, that's probably PACE. So if you think you have a PACE transaction, then you want to really make sure to develop the facts as fully as possible. First, you'll look to your client. Age is relevant, income is relevant, and preferred language is relevant. Why is age relevant? Predatory PACE salespeople target certain vulnerable consumer populations, and low-income seniors are one of those, unfortunately, one of those targeted groups. And it makes perfect sense from the PACE point of view, because at least currently, PACE eligibility is based on home equity. So a senior who has owned her home or his home for a very long time probably has a tremendous amount of equity in that property, even if the property itself is not terribly valuable. The amount of equity is the key. And the other thing is, home solicitations, door-to-door solicitations, are the explicit design of the PACE financing sales program. Who's home? Retired people. Who's usually retired? Seniors. From our point of view as advocates for these people, seniors with a fixed income are the most vulnerable. Seniors and disabled people with fixed incomes primarily, because they are the least able to recover from a predatory consumer transaction. Their income is not likely to increase or change. So that's why you want to focus on your client and get those details down. The next important thing, do they have a mortgage, or most importantly, a reverse mortgage? Why is that relevant? Well, because they are most at risk for foreclosure due to a PACE transaction. Next, I recommend you focus on the meeting itself. How did they come to meet the PACE salesperson? Was it at the consumer's home? Was it at their invitation? Very rarely. It happens sometimes, but it's rare. Or most likely, was it an unexpected door-to-door solicitation? Again, this is the very design of the PACE financing program, so that is the most common. Who was present? Who was present from the consumer side? Who was present, like family members or friends? And then the salespeople. You want to get the names of all the salespeople. Sometimes they go in teams. Why is that important? Well, at least technically, according to the Florida Home Solicitation Act, each salesperson, each solicitor is supposed to be individually permitted to make that solicitation. Almost never happens, but it's an important point to document for later. What was the language spoken during the meeting? Some of these presentations last hours. And you want to know, if the consumer is not an English speaker, what language did they speak? Did the salesperson speak in their language? Or if they're not as comfortable in English, did the salesperson speak in another language? This is all part of the confidence building process that occurs during the home solicitation. Ask what representations were made. Usually the client is quick to volunteer these. For example, what verbal statements were made about the cost, or about the savings, or about how it would be paid, or even tax rebates. We often hear that they were told, you pay nothing now, don't worry about it, you pay absolutely nothing now. They don't mention that they will pay when the tax bill comes, but there's a big emphasis on paying nothing now. You will save so much in electricity, for example, in the case of a solar panel installation, say, that this is going to pay for itself. Another big one is, yes, it might, there's a cost, but you're going to be eligible for a tax rebate. That may or may not, or a tax credit, that may or may not be the case, but you only get a rebate or a credit if you have an obligation to pay taxes to begin with, which many low-income people do not. Next big area of focus should be the documents and the signing process. Is there a contract? If there's a contract, was it in the same language as the negotiation? Usually, regardless of the language of the negotiation, the contract is in English. But you want to document that. Did the consumer sign anything? Sign a hard copy, or more likely, sign a tablet? Did the consumer receive a copy that day? This is important because the law requires certain disclosures. If you didn't get a copy, you probably didn't get timely disclosure. Do you have a copy of the contract? It's been astonishing to me, considering the size of many of these obligations, $10,000, $20,000, $30,000 obligations. There's no hard, the consumer has no hard copy. If they do have a copy, and if they have received it, make sure they send it to you, or you get a copy from them. I always ask, do you have a computer, and do you use email? In many of these cases, email is the primary means of communication, whether the consumer knew that or not. That can be pretty meaningless if you don't have a computer, but it can also be problematic if that is how the only version of the contract was sent. You want to inquire about materials left with the consumer and gather them together. They can be very important. Things like the door hanger, the little notice they put on the door, brochures they may have left. How about a business card from the salesperson? Actually, the Florida Home Solicitation Act requires that a salesperson leave a business card on every single occasion. And how about materials unrelated to home improvement? I've had several cases where the salesperson left something. A fellow allegedly, a book he allegedly wrote with devotionals, another with some inspirational religious material that the salesperson just thought the consumer might appreciate. Gather all this up. It's all part of the scene you are setting and the story you'll be able to tell for the context of these transactions. And finally, the improvements. One improvement or more than one improvement? Just windows, or windows and a door, or windows and a roof, or a roof and solar panels? Why is that important? Well, the PACE law limits the ratio of the cost of the PACE improvement to the value of the equity. And if that, it may be within the limits for one of those improvements, but if there are separate contracts for each particular improvement, the chances of the cost of the multiple improvements exceeding the limit for the property are pretty good. So you want to know, was there one or more than one? How about when did construction begin relative to the solicitation? Again, very important. Many contractors, especially if they sense an especially vulnerable consumer, begin the work, sometimes complete the work before the 3-day cancellation period has even expired. So note the construction start date relative to the solicitation. Be sure to get the names of all the contractors the consumer knows about. First of all, they're supposed to be, or is it the same entity as the one the salesperson worked for? PACE law specifies authorized that the contractors must be authorized. So you want to know, who are they? Who pulled the permit? Is it the same person as the contractor listed on the business card? And finally, is the installation complete? Did it pass inspection? Is it effective? Is it hooked? In case of solar panels, for example, are they hooked up to the grid? Your consumer will probably have a lot to tell you about that. So those are just some of the points you want to cover. I'm sure you will have great additions. I'd like to hear about them. But remember, it's so important to gather the info while the experience is relatively fresh. And for those of you who use Legal Server as your case management platform, put all the parties in Legal Server as the adverse parties. This is one way, maybe the most effective way, many advocates will be able to spot trends going forward and be able to effectively tell our stories. Okay, thank you.
Thank you, Ellen. That was really helpful. So we have just a couple minutes left. Unfortunately, we lost Chasity. I know she had a hard stop that she had at 1 o'clock that she had to get to, but we are happy to open it up to questions, discussions. Where I think we're especially interested in learning how both the government and legal aid and all the different entities that are interested in working on this issue can work together and help each other. So if you want to speak, you just have to virtually raise your hand and Alexis can unmute you and you can talk, or you can type a question or a thought in the chat or in the question and answer box. And while we're waiting for questions to come in, I'll just throw in my 2 cents. So I work for the city of Jacksonville, the general counsel's office, and our partnership with Jacksonville Area Legal Aid has been immensely helpful with us in our work on these issues. And so I encourage you, if you're with a government entity or if you're with legal aid, try to reach out to your local contact or somebody in your county or your city's office, because as Chasity said, almost every jurisdiction is working on this. And so it has been really helpful for us to be able to have the attorneys at JALA communicate directly with the consumers and obtain information that can be helpful to us just to kind of understand how these transactions are happening. And likewise, we've been able to kind of share with them our litigation and our strategy and kind of where we are with that. So it's a great partnership, one that I'm incredibly grateful for. And of course, Lynn is the touchstone in getting that done as always.
And Laura, I'm going to throw up another slide that we have since we have a little bit of time. Bear with me and my technology, but this might, fodder a little more conversation. So bear with me.
Yeah, so Lynn put together this really helpful slide of potential causes of action for the PACE loans. So she's got some statutory causes of action as well as some common law causes of action that might be useful in representing consumers who have PACE loans.
Yeah, and I can go ahead and start if that's not going to be distracting, Alexis, but it's basically the same causes of action slide that I used at the presentation in St. Augustine last month, except for we had to cross out a lot of the options that were available, because it's an example of some of the 2 laws that we won't be able to take advantage of, either whether the new law passes or not, is the Federal Truth in Lending Act, because it's the same old story, except the stakes are higher. Just like the payday loans and small loan, you call something else, and that takes it out of the protections of another law. So we don't follow if it looks like a duck, quacks like a duck, etc. So we don't have truth in lending. We looked into some FHA claims because we find these very heavily marketed in majority minority neighborhoods. Doesn't apply. I say that with the caveat that we've not quit working on trying to figure out a way to make them apply. But the consumer protection language in the present bill is not going to provide a lot of remedies. Ellen brought up some incredible points about the door-to-door sales, Florida home sales and financing requirements. And a lot of the places, the FTC, where we will find cooling off periods. So those are still options. The Florida Unfair and Deceptive Trade Practices Act is still an option. Bob Murphy mentioned at the January event that the Credit Repair Organizations Act was a very helpful law, because these are marketed, as you hear at the legislature, these loans are the lifeline for seniors who can't get a new roof, but they can get a super lien at 9% with actually no limitations on the cap in the law. Somewhat frightening. So there's a lot that doesn't apply. We're still working on it, but I think the one key thing, another key thing that Ellen mentioned was check the paperwork. Because as I was testifying today, I was explaining to the legislators who have no idea that this is the way it works, that none of these transactions are handled with paper. It's all handled on a small handheld device. And so if you look at, so some of the disclosures that are already required is, what's the interest rate? How much are you borrowing? In the sample contracts for Fortify, you will find the interest rate on page 19 of a 21-page document. You will find how much money you are borrowing on page 18 of a 21-page document, and you will find the right of rescission in the bottom paragraph of page 10 of this document. How many elders, particularly ones who don't even have an email address, but one is made up for them, are how often are they going to be able to, the vendors going to be able to comply with the e-Signs Act, both the Florida and the federal. So I think right now that's where our strength is, but we're continuing our efforts to find other methods of bringing consumer claims when there does not seem to be a lot readily available within the statutory provision, the one that was heard today and maybe become law, or the last one.
Awesome.
Right.
Thank you so much, Lynn. So,
Yeah.
Laura, do you have anything you wanted to add on that?
I do not, and I don't see any questions or discussions or anything, but I encourage people, if they have ideas for how we can tackle this, to please reach out or share.
Absolutely. And so I also checked, I don't see anything in the chat or the Q&A. Before I thank everybody and send everyone on their way, I want to, circle back to two housekeeping matters. First and foremost, I did pop the CLE code into the chat. That CLE code is 8363. Again, that's 8363. One general CLE credit. You'll receive that code in a follow-up email, so don't worry if you didn't get to write it down. And I also want to mention, I think we mentioned it earlier, but I can't remember, that the Public Interest Law section of the Florida Bar is a co-sponsor to this. And you all should think about joining PILs. This is how we get that collaboration. This is how we get, people to bounce ideas off, and a community really focused on trying to do the same thing, or things that matter to the public interest community. So anything else before I say goodbye?
I'll say, and stay tuned for our next webinar next month. Will be on student loans.
Yes. As we all know, we need more information on that, because it sure is clear as mud all the time. So you all will receive notice of that as well. Ellen, Lynn, Laura, Chasity, I know she had to leave. Thank you very much for this. Thank you for all that you're doing in sort of pushing the narrative and the conversation on this, to make sure that vulnerable populations aren't taken advantage of.
Thank you, Alexis, for running all the organizational background.
It's my pleasure. You make it easy. To all the folks in the audience, have a wonderful rest of your day, and we will see you at the next one. Bye.